Start. On behalf of the respondent number 2, it was contended that no specific allegations against the members of the BCCI or directors of the Indian Cement Limited have been levelled and therefore the plea based on conflict of interest was rightly negatived by the High Court. Full stop. It was maintained before this court that India Cement Limited is a company, which is managed through a board of directors of which respondent number 2 is the vice chairman and managing director, but his holding of shares is only 5%, and therefore it is wrong to say that the respondent number 2 takes decision about approval of the board of directors of the company. Full stop. What was pleaded was that India Cement Limited has thousands of shareholders and the company has an independent legal existence from its shareholders, whereas all the decisions regarding management and administration of BCCI are taken by its managing committee consisting of 9 members, of whom the respondent number 2 is only one of the members, and therefore there is no conflict of interest as is claimed by the appellant. Full stop. It was further argued that all the decisions of the managing committee of the BCCI have to be approved by its general body, and as there are no specific allegations against the members of the general body to the effect that there were also acquitted by malafide in favoring the respondent number 2, the plea based on conflict of interest should not be entertained by this court. Full stop. Para. As noticed earlier, the learned single judge of the High Court before whom the suits were instituted as well as the division bench of the High Court have refused to grant equitable relief of injunction claimed by the appellant. Full stop. This court is of the opinion that grant of interim relief as prayed for can amount to decreeing the suit without adjudicating the claims raised in the pleadings of the parties. Full stop. Such a course is not permissible at all. Full stop. This court has deprecated the practice of grant of interim relief which amounts to decreeing the suit in several reported decisions. Full stop. The averments made in the plaints would show that the final relief claimed are almost the same as claimed by way of interim reliefs. Whether the appellant is entitled to equitable relief of injunction or not, will have to be decided after several questions raised in the plaints are decided on the basis of evidence, which may be adduced by the parties. Full stop. The questions of law sought to be raised by the appellant are at the best mixed questions of law and facts. Full stop. As observed earlier, the appellant has failed to disclose certain material facts, nor the appellant has been able to prima facie establish that his legal rights have been violated as required under sections 34 and 41 of the Specific Relief Act, 1963. Full stop. No material is placed by the appellant on the record of the case on the basis of which a reasonable finding can be recorded. Full stop. Para. Before the High Court, the contention of the appellant was that the suits were filed by him in the capacity of past president of BCCI, as he was an administrator within the meaning of the said phrase as defined in clause 1 (n) of the regulations. Full stop. The respondent number 1 contended that the suits were instituted by the appellant in his individual capacity and therefore The decision would be binding only on him, but the nature of the reliefs claimed indicated that the suits were filed in public interest and therefore the suits in individual capacity were not maintainable, full stop. The High Court noticed that the proper course for a person for instituting a suit in representative capacity was to obtain permission of the court before instituting the suit, full stop. The High Court found that in the present case, no such permission was taken even after filing of the suits, full stop. Having to so held, the High Court expressed opinion that this question could be decided only after trial was held, but for the purpose of grant or refusal of the injunction orders claimed only a prima facie consideration was required, full stop. Para, who was the leaseholder at the time of acquisition of the land, full stop. The remaining 10.88 acres of land continued in the possession of the father of the petitioner, full stop. In the meantime, the father of the petitioner expired and the lease which was granted in favor of Ram Lal was transferred in favor of the petitioner and his brother Rajendra Kumar, and the names of the petitioner as well as Rajendra Kumar Suri were entered in the revenue records, full stop. The petitioner's claim is that under the provisions of UP Government Estate Thekedari Abolition Act, 1958, the petitioner has acquired right of heritable tenant, and as such, even on the expiry of the lease on 30th June 1980, full stop, the right of the petitioner had continued, full stop. Para. After the expiry of the lease granted in favor of the father of the petitioner, the respondent authorities proceeded to evict the petitioner from the land in question, full stop. The petitioner filed a civil suit in which temporary injunction was rejected, full stop. The petitioner as well as his brother filed an appeal before the lower appellate court, which was dismissed, full stop. The petitioner as well as his brother filed civil miscellaneous writ petition number 2832 of 1984, Rajendra Kumar Suri versus State of UP and others, in which this court, after considering the totality of the circumstances, held that the claim of the petitioners was up to 31st June 1982, full stop.